It's my pleasure to welcome our presenters today, and we'll go ahead and have the first presenter introduce themselves, and if you want to provide a little background information, and then Insha and Katie, you can also introduce yourselves as well.
Certainly. I'm just seeing if I can't start my video, but can everyone hear me speak? I don't know.
I can hear you, Anne. I can hear you.
Oh, fantastic. Hi, everybody. Happy to be virtually with all of you today. My name is Ann Patterson. I'm the Senior Vice President of Steps to End Family Violence. We're a program of a larger organization called Rising Ground.
Insha and Katie, did you want to offer your introduction as well?
Hi, this is Katie Schaefer. I have been working on bail reform and pretrial justice issues for a number of years now, and worked with Anne and other survivor advocacy organizations and survivors in that work. I was formerly at Just Leadership USA and have been consulting for the past half of the year at the Brooklyn Community Bail Fund, Center for Community Alternatives, and a few other organizations.
And hi, everyone. I'm Insha Rahman, and I work at the Vera Institute of Justice. And I was a longtime public defender before coming to Vera, so bail and pretrial and discovery issues firsthand from that perspective, as well as at Vera. I lead our work on bail and pretrial justice, and worked closely with Anne and Katie and others. I'm sure of you who are on this call on the reform that were passed back in April. So looking forward to talking with you all. Thanks so much for joining us.
Thank you all. So we will begin, and I will hand the floor over to you. You should be able to see your presentation, and as soon as you need me to click through the next slide, just let me know, and you can go ahead and get started.
Certainly. So again, really delighted that Ms. Casa has convened this webinar, and especially honored to be in the company of both Katie and Insha, given how central they've been in this work to push for these vital reforms. So I'm happy to be here. So I wanted to, if you want to go to the next slide, Selena. So I wanted to give a little bit of context about what grounds me in this work, because all of us are going to react to these reforms based on who we are and where we work. So I think it's necessary that we're aware of that, and we name the impact that our lived experiences and the place in which we do this work impacts the way that we think about these reforms. So I have the tremendous honor of working for a program called Steps to End Family Violence. We are, like so many of you, a mainstream anti-intimate partner violence program, meaning we are explicitly committed to supporting survivors of intimate partner violence, along with children impacted by abusive partner behavior. And we're committed to offering them a whole range of holistic supports. We are a heavily therapeutic program, so we really focus on healing. We do lots of long-term therapeutic work with survivors and their children, with a real hope of sort of accompanying them on their journey to trauma recovery. We also recognize that we can't do healing work if we are not also spending as much time doing prevention work. We would love to see the time when all of our healing work would just evaporate, because the power of our prevention work has been so significant, and that we have completely disrupted the continuation of intimate partner violence and other ways in which we harm people in our intimate relationships. So that's the perspective that really calls me to this work. And the thing that really, so I wanted to just name that we at STEPS are deep, deep survivor advocates. We care profoundly about survivors and survivor well-being, and we are really committed to supporting systems to evolve and change so that they better support survivors, and that they better support a diverse community of survivors. And the community of survivors that we are especially committed to supporting at steps are what a group of survivors we call invisibilized survivors. So survivors, as a consequence of who they are or the systems that they're involved with, that their survivorship is systematically ignored. Most germane to this conversation is that we are committed to elevating the survivorship of criminalized people. We recognize that once you have been arrested and assigned the label of defendant, that doesn't mean that your survivorship has been erased. In fact, most likely it is your desperate efforts to survive or resist that have resulted in your criminalization. So that feels really important to us at Steps, that we name the survivorship in places where it's ignored. And another thing that that does is it really challenges this antiquated binary of both a person who survives harm and a person who causes harm. We absolutely know that each and every one of us have the capacity to cause profound harm as well as survive tremendous violence. So we like to challenge that binary, that that all of those identities live within all of us. So that's the perspective that I come from, and I really encourage everyone else, and I know this group has done this, to really name the perspective that influences the way that you understand these reforms. We could pop over to the next slide. So Selena, if we could have the next slide. Fantastic. I think, just as I think it's really valuable to name the perspective that influences the way that you understand these reforms, we want to create a tremendous amount of space to be in conversation with survivors about the full range of feelings that they're having in the face of these reforms. So it's our responsibility as survivor advocates to intentionally create space for survivors to talk about the full range of feelings that they have following an abusive partner's arrest. And just, again, to underscore my perspective, I'm going to primarily be talking about how these reforms impact survivors of intimate partner violence, so people who know the person who has harmed them. But I think a lot of these points are really relevant to people who have been harmed by someone who is not known to them or not well known to them. So we need to create this space where survivors of harm can talk about the full complexity of the feelings that they have following the arrest of someone who's caused them harm. And we create that space not only in the words that we use and the perspective that we lend, but also just the way that we physically host our space. So look around the space where you support survivors. Do you find that you have an abundance of posters from the federal Office on Violence Against Women? Do you find that you have a lot of information hung up about how to contact your local police department or how to reach out to your local prosecutor's office? Do you have other materials around your space that talk about other ways that people can respond to someone harming them? So definitely look around your space and see, like, what are the silent messages that I'm communicating by the way that I decorate or hold my space. I think it's also really important to think about those of us who are embedded within district attorney's office. Like in New York City, many survivor advocates are at family justice centers, which are hosted by district attorney's offices. And we might think that we've been able to maintain this bright line between our survivor advocacy and the prosecutors who share our office space. Just be very aware about what messages we're communicating to survivors. And in addition to the way that we're communicating through the space that we create for survivors, let's actively be in conversation with survivors about the full range of feelings that they have following the arrest of someone who has caused them harm. Every single one of us on this call knows that survivors do not speak with a single voice. That survivors of intimate partner violence, sexual violence, other forms of interpersonal violence are not a monolith. And everyone has a wide range of reactions to the harm that they have just experienced. Let's be sure that we're talking to survivors about all of those things. And let's make sure that we are not consciously or unconsciously limiting the things that they share with us. And I think that has to begin by examining our own thoughts about how people should respond in the face of harm. Many of us absolutely believe that when someone has harmed us, that a very meaningful response to that harm is involving the criminal legal system. And I think many of us, especially many of us who are white people, were raised to believe that the police and prosecutors are there to keep us safe and to hold people responsible when they have harmed us. That absolutely can feel healing and necessary to some survivors of harm, that the idea of being able to rely on the criminal legal system to respond to our needs in the face of harm. We need to make that option available to everyone, but we also need to recognize that accessing the criminal legal system may be the very last choice for some survivors of harm. We actually know that Insha and Katie are going to dive more deeper into the research, but we also know that the majority of people who have been harmed by someone else don't have contact with the criminal legal system. Most people rely on those who are closer to them. Most people rely on their friends, their family, their community members, their local hospitals, their schools, their faith communities. Very often people who've experienced harm rely more on us, survivor advocates, than they ever do on the criminal legal system. So just keeping that in perspective feels really necessary. And that's the research that I'm speaking of when I talk about considering the research. When survivors of intimate partner violence or other forms of intimate or personal violence experience harm, most folks don't reach out to the criminal legal system for a variety of reasons, a really wide spectrum of reasons. There are those folks who actually have been further harmed by the criminal legal system or have tremendous worry about what that criminal legal system will do to the person who has harmed them. There are some folks who just don't know how to reach out to the criminal legal system. There are some people who have reached out to the criminal legal system before and have been failed by that system. At STEPS, we do a tremendous amount of work with criminalized survivors of intimate partner violence. Many of those survivors have the only time that they've had contact with the criminal legal system is when they've been arrested, because any other time they've sought even the basic help from the criminal legal system, they have been ignored, they have been harmed, and that has had a chilling effect, and that they have no interest in continuing to seek support or healing from the criminal legal system, which is only caused to further harm them. So let's dig into the research, but let's also recognize that the research is not all that there is. So if we Selena want to go to the next slide, I'm thinking about defining safety. I think just one more note about research. I think it is really vital to look at the research and what the research tells us about how survivors of harm engage with the criminal legal system. But I was raised by a mother who said that statistics don't matter when something awful has happened to you. And I think that's important for those of us who are survivor advocates to hold on to that, because how many of us have sat across a room from a survivor of harm who has reached out to the criminal legal system and has told us that that one day that their abusive partner was held on bail was a day that made them feel safe. So let's absolutely listen to the research that tells us, and Insha and Katie absolutely dive into this, that that money bail does not promote survivor safety. We know that intellectually to be true, but that can be hard to remember when we're in conversation with a survivor who has relied on that one day that their abusive partner has spent in jail before. And definitely be compassionate and loving and gentle with yourself and with that survivor when they're feeling grief or anxiety or worry that they no longer have that one day that their abusive partner is being held in jail. Let's create a lot of space for us to have the full range of experiences in reaction to these reforms, so we can create all that space for the survivors that we're committed to supporting. And I think that all of us have found in the work that we do that the one thing that we can do above all to support the safety of survivors of intimate partner violence or sexual violence is to create meaningful opportunities for them to activate their agency and mobilize their self-determination. We know that the opposite of threat is not safety, but it's self-determination. Because when survivors are given access to their own wisdom, to really focus on the different ways that they have used to keep themselves safe, that's when they are safer. So let us do whatever we can in supporting survivors of interpersonal violence and promoting their self-determination. So this means not prescribing what we think survivors should do. We want to create big and abundant space for survivors to do what they know to be right to keep themselves safe. And sometimes we all know, we've been in conversation with survivors who are just absolutely at their wits' end, and their creativity is absolutely maxed out. and they sort of or have run out of creative ways to keep themselves safe, that's when our role as survivor advocates become the most vital. That's when we want to lend survivors our creativity. That's when we want to be in conversation with survivors to think about all the different ways that they can activate that self-determination, that they can make their own choices to keep themselves safe. I also think it's really important that the criminal legal system before these reforms, and for some survivors, the criminal legal system before these reforms, maybe it did honor survivor agency, but in many ways it didn't. You know, we live in a mandatory arrest state. So when someone harms their intimate partner violence, if a mandatory arrest assessment is done properly, then the predominant aggressor should be arrested. But we know that doesn't always happen. And in a mandatory arrest state, a survivor's abusive partner can be arrested over their vocal objections. And that doesn't honor their agency or self-determination. So the criminal legal system before these reforms didn't, in many, many ways, honor survivor agency at all. I mean, I can think of hundreds, without exaggeration, hundreds of examples when I would be on the phone or in conversation with a survivor whose abusive partner had just been arrested, sobbing, telling me that I never wanted him arrested. But now the police officer told me they had to arrest that person. And they come and they meet with the prosecutor's office and they're begging, desperately begging for the prosecution to stop. And the prosecutors tell them, we have an approach in our office, a mandatory approach to prosecution. So we're going to continue with this prosecution even over your objections. So even before these reforms, survivor agency was pretty limited by the criminal legal system. And so I think that people are often thinking, hi everybody, people are often wondering now, did these new reforms enhance or compromise survivor agency? I think in many, many ways, if these bail reforms are done right, these reforms are going to enhance survivor agency. And this is going to be very different across the state. If there's ample support in prosecutors' offices to reach out to survivors who are, for prosecutors to reach out to survivors at the point when they're making these early case determinations, then there's real opportunity for survivors to absolutely deploy their self-determination. And that's what keeps survivors safe. When survivors have a real and meaningful say in what happens to the person who has caused them harm. So I think if these reforms are executed effectively, they have the real possibility to really enhance survivors' sense of agency at the very beginning of a criminal case. So if we go to the next slide. So in addition to recognizing that our responsibility as people who support survivors of harm is to create as many opportunities for them to activate their own self-determination, we also have to meet that with knowledge and expertise. Because while survivors have the expertise on their own experience, and they have the real expertise on understanding what will and will not impact their abusive partner's behavior, it's our responsibility as advocates for survivors to know what's happening in our local jurisdiction. These reforms are very, very new. Jurisdictions all across the state are responding to these reforms in very, very different ways. So it's our responsibility as advocates to know what's happening in our local communities and to share with the survivors that we support exactly what's happening. Is there supervised release in your communities? Is that supervised release well funded? Is it functional? Is it being swiftly and effectively implemented? It's our responsibility as survivor advocates to know those things. Very often, those of us who are advocates for survivors have really strong relationships with prosecutors and police. That is a vestige of the battered women's movement's over-reliance on the criminal legal system. And as a consequence of that, many of us have really good relationships with police and prosecutors. We are only now, and this is not true for every advocate, but sort of large scale, we are only now really forming those relationships with defense attorneys. So it's our responsibility as these reforms are rolling out that we as survivor advocates are forming stronger relationships with defender service organizations in our local communities and other folks working for justice reform. Because if we are only in conversation with prosecutors and with police, we only can understand these reforms from that single perspective. And that single perspective may not support all the survivors that we're committed to caring for. So this is an opportunity for us to really understand what's happening in our local jurisdiction and start to build new relationships or enhance existing relationships. And if there's anything that we have to do with survivors all of the time, but especially when reforms are being enacted, is that we have to really tighten our safety planning work. Working with survivors of intimate partner violence, working with survivors of sexual violence, working with survivors of other forms of interpersonal violence, the central part of that work is safety planning and risk assessment. That work always needs to be dynamic. That work can never rely on a fill-in-the-blank template. But it's at times like these where that work needs to be even more dynamic and even more constant because the landscape is shifting. Those old approaches to safety planning that we used to rely on do not work any longer. So it's our responsibility to just remind ourselves, these are one of these moments that calls on us in the chaotic world of survivor advocacy to pause and to think about the way that we're shifting our safety planning work in the light of these new reforms. So Selena, if we can go to the next slide. So let's remind ourselves what safety planning is and what safety planning isn't. What it is, first and foremost, especially those of us who work with survivors of intimate partner violence and those of us who work with survivors of sexual violence, specifically when the person who has harmed them is known to them, this is the central part of our work. The central part of our work is risk assessment and safety planning. And what does that mean? It does not mean relying on a template. It does not mean relying on a checklist. It means being in embodied, dynamic, alive conversation with a survivor about what keeps them safe and what endangers them. It also means acknowledging the reality that we all know to be true, which is that we can do absolutely everything, but ultimately the person who is primarily responsible for that survivor's safety is the person who is harming them, as well as the systems who are harming them. And to see how sometimes those two systems can work together, that an abusive partner can be supported by state violence and acted by police and prosecution. That is not universal, but it does happen with some frequency. So we need to make sure that our safety planning is alive and it's dynamic. It's not our responsibility to frighten the survivor. That actually can disrupt anybody's approach to keeping themselves safe if they're walking through the world in a constant state of fear. We don't ever want to ignore that fear or trivialize that fear, but we don't want to add or contribute to that fear. And we as advocates need to do a tremendous amount of self-examination and say, as an advocate, it is not my role to encourage a survivor to make one decision over another. It's my responsibility as an advocate to open up the infinite possibilities for a survivor in keeping themselves safe. We need to be creative and expansive in thinking about what keeps survivors safe, because it's not only orders of protection, it's not only entering shelter, it's not only calling police, it's not only participating with prosecution. It's so many more things, but I think when we only think about those very reduced ways of keeping survivors safe, we might be unintentionally quashing some of survivors' creativity. And for those of us who are survivor advocates, we know there is no more creative group of people than survivors of intimate partner violence and other forms of interpersonal violence, because the creativity is what keeps them alive. I think our goals are to create big, abundant space to think about the infinite ways that survivors keep themselves safe, and to name those. Survivors know that, but they may not be naming what they're doing as keeping themselves safe. We all know survivors who have developed relationships, say, with their kid's kindergarten teacher, and they have made that relationship so that the kindergarten teacher allows them to drop off their kid to kindergarten early rather than a little bit late, because they know that if they can drop the kiddo off one day early, the next day at a different time, then that is a way of keeping themselves safe. They might not even be naming this as a safety strategy. They just think about that as a way to get through my day. And it's our responsibility to really highlight and celebrate the fact that survivors are engaging in these safety strategies all the time. And actually, most of those safety strategies are taking place outside of the criminal legal system, relying on friends, relying on neighbors, relying on their own creativity and innovation. It's our responsibility as advocates to name those things and really celebrate those choices as safety strategies. We also have all been in conversation, as I mentioned before, with survivors who have run out of ideas. Because sometimes the crush of being partnered with someone who's abusive towards you can sap your creativity. That's when we lend ours. And that's the stuff when survivors and advocates work together, their creativity is amplified, it's multiplied. So that's when we really want to, and this is when we can draw from the many conversations that we have had with other survivors to be like, without violating the confidentiality of other survivors, and talk about, oh, I know I was talking with someone the other day and she's using this strategy and that seems to be really effective for her. So this is when we unite our creativity with survivors' creativity and the wisdom, the collective wisdom of all survivors. And in doing this work, doing the safety planning work, we have to make sure it's alive. It cannot be a template. It cannot be a checklist. You need to be engaged. You need to be present in this work, and you need to do it every single time that you interact with a survivor of harm. Every single time. Very often, meeting someone's immediate needs can feel like the only thing that matters in that session, but we need to make sure that we're always checking in on that survivor safety plan. And that is as simple as saying, how are things going? Tell me have you had contact with your partner this week? What things have been happening? So just remember that safety planning needs to be the central part of our work with survivors of intimate partner and other forms of interpersonal violence. It needs to be dynamic, it needs to be alive, and it needs to be full of creativity. So Felina, we want to go to the next slide. So in doing that safety planning, in addition to lending our creativity, we need to leverage our connections. We always need to be aware that as survivor advocates, we cannot be gatekeepers, we must be gateways. We have, as a consequence of the spaces that we occupy and the power that is afforded us by our position, as well as very often our racial identity, our gender identity, we have connections that survivors may not have. And we need to leverage those connections to keep survivors safe. And like I mentioned before, those of us who are survivor advocates might be really comfortable in relationship with police officers or prosecutors because that is a longer standing relationship. But let's use these reforms as an opportunity to build broader relationships. Let's work on building relationships, as I mentioned before, with defense, with your local justice reform advocates. But let's also recognize that survivors consistently tell us that the things that keep them safe are stability, housing stability, economic stability, access to reliable and affordable childcare, access to high quality medical care, access to really meaningful anti-oppressive mental health treatment. So let's leverage those connections to really support survivor safety holistically. And let's also seize this opportunity for a little cross-movement organizing. Survivors of intimate partner violence are fierce and smart organizers when they're given the opportunity. So let's create opportunities for survivors of intimate partner and other forms of gender-based violence into organizing campaigns that they typically have not had a meaningful voice in. In New York City, we've seen a really exciting role for criminalized survivors of intimate partner violence in the Close Rikers campaign, because that's a voice that's pretty underrepresented. The voice of survivors of intimate partner violence who are detained at Rikers Island. That voice has historically been underrepresented. But when those survivors take a central place in those organizing campaigns, people listen in a different way because people's still, and I'm still surprised every moment by this, people are still shook to hear that survivors of intimate partner violence are held in jail for trying to keep themselves and their children alive. So let's create these opportunities for cross-movement organizing. Let's bring survivors of intimate partner violence into movements for fair and affordable housing. Let's bring survivors of intimate partner violence into the movements for a fair and living wage. Because survivors are impacted by everything, and survivors' safety is supported when their lives are more stable, when they're more rich, when they're more whole. And finally, we can go to the last slide for me. Finally, in doing all of this work, let us remember to care for ourselves and care for one another. Let us remember that we want to start the cycle of gentleness and compassion by treating ourselves with gentleness and compassion. So if we are in conversations with a survivor and the survivor is making a choice that makes us feel panicked, and worried, if it kicks up feelings of judgment, how about maybe some feelings of superiority? Let's name those feelings, and let's not beat ourselves up because we're having those feelings. Let's be aware of those feelings and those sensations. Let's be aware about how we are or are not bringing them into our work with survivors. We often think that we're not, when we have those feelings of judgment, because those feelings of judgment will always come. When we have those feelings of judgment, let us name those and be acutely aware about how they're showing up in our direct practice with survivors. Because if we have an awareness of them, we can make sure that they are no longer, that we're not bringing them in to our relationship with survivors, that we're not subconsciously judging them. I think I've seen this in my own practice. When a survivor is making a series of choices that make me feel anxious, I become judgmental. And then when that survivor reaches out to me, maybe I'm a little slower to return her call. I think we have to cultivate this awareness. And when we have this awareness, we need to be kind and compassionate with ourselves, and we need to commit to changing. Because when we're kind and compassionate with ourselves, we can be much more kind and compassionate with the folks that we are committed to caring for and supporting. We also need to be very self-aware at this moment. We need to be very aware of all of our reactions to these reforms. We need to be very aware of the impact that media coverage is having on all of us. A friend and brilliant activist, Serena Ligori from New Hour in Long Island, just wrote a really beautiful piece that appears in Newsday either today or the day before about being very aware of how, and this is the language that she uses in her piece, about how fear-mongering is impacting the way in which we understand these reforms, and that how these reforms, which are designed to create justice, are being criticized by saying that they're harming survivors. And I think it's really, really important for us to recognize that survivors don't speak with a single voice, and many, many survivors of intimate partner and other forms of violence will not be harmed by these reforms, and in fact, will experience a greater sense of justice as a consequence of these reforms. So let's be very aware of the impact that this media coverage is having on all of us, and to just be critical of that exceptional story. So that the story about the one time that these reforms caused more harm to one person, in no way should we trivialize that harm. In no way should we erase that story, but we must put that story into context. That we must recognize that an exceptional story isn't the norm, and that these reforms, if the way in which these forms have taken shape in other places where they have happened, they promote significant public safety without meaningfully endangering survivors of intimate partner violence. And they have, and this is where my heart sort of lies, they have the most profound and radical impact on criminalized survivors of intimate partner violence. Some of the most more marginalized and most harmed survivors of intimate partner violence. These will have radical impact on criminalized survivors of intimate partner violence. These are mamas who are survivors of intimate partner violence who won't have to be separated from their kiddos because they were using force to protect their children's lives. So let us just be kind and loving and gentle and compassionate with ourselves and with one another and all of us around us, including my co-presenters, Katie and Insha, who will take it away.
Thank you so much, and I really appreciate what you have to say. So I'm gonna talk a little bit about why we worked on these changes, both those of us who came to this work from a criminal justice reform perspective, as well as to Anne's point, there was a leadership team of survivors, mostly survivors who had been criminalized, who really led the way in organizing for bail and discovery reform legislation. And so I want to take a little bit of time to talk about why we have spent years doing this work, and then I'll pass it to Insha, who will talk a little bit about what the legislation will do. So Serena, if you could go to the next page. And the next one. So across New York State on any given day, there have been about 22,000 people in local jails. So these are people just in local jails, not in state prisons. And the vast majority, 67%, have been there pre-trial, meaning they've not been convicted, and they're there overwhelmingly because they cannot afford bail. Next slide. This is a system that leads to the criminalization of poverty. In New York City, the average amount for misdemeanor bail is $1,000. In Buffalo, it's 5 times that amount. This is an interesting place where people sometimes think about jail as a New York City problem, but the majority of people in local jails are in jail outside of the 5 borough, and money bail is much more expensive outside of the 5 boroughs of New York City. So if you look at these amounts, $1,000 as a misdemeanor bail, $5,000 in Buffalo, and then you look at the national statistics that 40% of Americans don't have $400 in emergency funds, you can see the ways in which money bail, which was designed to be a mechanism to ensure that people came back to court, here's bail, okay, when you come back to court, we'll return this money to you, becomes a mechanism of detention. But it doesn't become a mechanism of detention across the board. It specifically becomes a mechanism of detention for people who cannot afford it, for poor people, for low-income people. The New York Civil Liberties Union last year released a report where they looked at 8 counties across the state, and they found in just 5 years' time, tens of thousands of people who had been held on bail of $500 or less. And there's just nothing that you can look at for a bail of $500 or less that leads to somebody spending days or weeks in jail other than the criminalization of poverty. And so this has been a system in which people with access to wealth pay bail and they go home and they come back for their next court date, and people who do not sit in jail. Next slide. So there are a couple of things when we think about sort of what has been unjust about this system that seem most salient. So we've talked a little bit about the criminalization of poverty. The other thing that I think is important to mention is just the basic ways that money bail and pretrial detention violate the presumption of innocence. That one of the protections that we hold most dear as sort of core to our constitutional rights is the right to be treated as innocent unless proven guilty. And pretrial detention and money bail fundamentally violate that. It means that for poor people, for working class people, that you are treated as guilty until you can prove otherwise. This is also a system that has targeted Black and brown communities, that bail has both been set at higher rates for Black and brown people, and that they have been less able to make it. And in that same NYCLU, the New York Civil Liberties Union report that I referenced earlier, what they found in the 8 counties they looked at was that white New Yorkers were twice as likely to make bail the same day it was set as Black New Yorkers. So that means that when white people are able to pay bail, either because it's set at a lower amount or because of the ways that systemic racism has become entrenched in economic systems, that means that they are able to go home to their families and their communities, and that Black New Yorkers are then sitting in jail pre-trial. The other thing, and Anne spoke to this a little bit in reference to people's kiddos, that money bail and pretrial detention have devastating consequences for people's lives, and then consequently for their families. That if you work shift work, it only takes a night in jail to lose your job. It doesn't take much longer than that to lose your apartment or to fall behind on your mortgage, to lose custody of your children, or to not know who's picking your child up at school. And so these ripple effects not only target people who are least able to afford it, target people who are economically disenfranchised who cannot afford bail, it then contributes to people's economic instability. You are then in jail, you've lost your job, you've lost your apartment, your family has potentially lost your caretaking work, who's taking care of grandma, who's taking care of your disabled brother. And so those those effects ripple outwards to families and communities, and particularly for the communities that have been deeply harmed by this. Because while we talk about mass incarceration, many advocates have pointed that what we really mean is hyper-incarceration, that it is particular communities that have been most targeted, who see sort of the exacerbation of these harms. And then the final thing is that money bail and pretrial detention lead to the coercion of plea deals. They lead people to plead guilty out of desperation. And this is at a confluence of factors. So if you can imagine somebody who's sitting in jail pretrial, because New York had terrible speedy trial laws and terrible discovery laws, you were sitting in jail, you had no idea when you might get back to court. You didn't have any of the evidence in your case, not even the most basic information like what the police report said. You're sitting in jail on bail you can't afford. You sit there for a couple of months. And then the prosecutor comes to you and says, I'll give you time served and you can go home tomorrow, but you have to take this plea deal. The vast majority of people will take that plea deal. And so this system ends up creating an assembly line of convictions, that it is highly efficient and deeply unjust, that it means that people are not getting access to trials, they're not getting access to due process, and that lack of fairness is being distributed on the basis of wealth. And so this was sort of some of what motivated it. And then sort of in addition to or beyond these sort of top line ideas, what really brought me to this work were people's stories. So I want to share two stories of people who were instrumental in getting this legislation passed. One is a person named Priscilla, who lives in Westchester, and came to Albany more times than I can count, was involved in bringing in faith groups and others in Westchester to support these reforms. And she came to this work because she was the survivor of an abusive marriage. And she had actually been somebody who had called the police a couple of times. Nothing had happened. And then finally the police did come at a time in which Priscilla had tried to stand up for herself. And she was the person who was arrested. And she got taken to the county jail, and bail was set at hundreds of thousands of dollars. And she couldn't afford it. And she sat in jail, and she had 2 young children, and she worked with her family to try to create alternate arrangements for them. And she sat in jail for 2 years pre-trial because she wasn't interested in taking a plea deal to something she had not done, to not having her day in court to talk about what it had meant for her to be a survivor. And finally, after 2 years, with no trial on the calendar, with no turnover of discovery, she finally took a plea deal. It was the only way she could see to get home to her kids. And so she took a plea deal and she went home. And she, to Anne's point about the unbelievable resilience and creativity, despite having experiencing the various kinds of discrimination of somebody who has a conviction, she has become an entrepreneur, she has become an advocate, she has become an activist, she is doing unbelievable work. And then she was a real leader in the fight to end money bail and to see the passage of bail reform and discovery reform legislation. The other story that I want to share is the story of Eileen Mayer. And Eileen is an advocate with Vocal New York. She has worked on, speaking of the intersection of issues, she has worked on housing issues, she has worked on criminal legal system issues. And she came into this work because she was arrested for something that her abusive partner had done. She was arrested on larceny charges. And I think that this is an experience that I'm sure many of you have seen. And she sat in jail on bail she couldn't afford. And after a couple of months, she didn't see any other way other than sitting in jail for years until the possibility of a trial. and so she also took a plea deal. And she tells, she was just on a webinar with me last week. She tells a really beautiful story about the moment that she decided that she was going to be involved in changing this system. And so it's the stories of these folks, it's their courage, it's their advocacy that has sort of continued to light a fire for me to do this work. Next slide. And so we have worked with both individuals like Priscilla and Eileen, but also with organizations across the state. So Anne and I have worked together. The New York City Anti-Violence Project has worked really closely on these reforms, Girls for Gender Equity and others. And they have done this work thinking about particularly the impact of these systems on marginalized survivors, on what it means for survivors who are criminalized, either for standing up for themselves or for something for which they were coerced or blamed for related to their abusive relationship. And so there have been, and I'm happy to share, Selena and the folks at Miss Casa have these various letters and statements that are really powerful in how they talk about what it means to support queer survivors, trans survivors, Black and brown survivors, survivors who have been criminalized, survivors who are immigrants, and the kinds of impact that a system of money bail and of wealth-based detention and of denial of evidence in a case has meant for the survivors they've worked with. Next slide. Turns out I'm not doing these in order. Next slide. Thank you. And so I'm just going to highlight, this is laid out much more comprehensively in some of these open letters, but I just wanted to highlight a couple of the issues that we heard survivors and that survivor advocacy organizations, as we were working on bail and discovery reform, talked about most often. And so one, and Anne spoke to this, and Priscilla and Eileen's stories also spoke to this, that survivors are sometimes arrested. And that can mean, that can be because of mandatory arrest laws or poor primary aggressor assessment by law enforcement. And we can see in some of the data, some of the surveys, the extent to which this is true, that this is not sort of a single experience, but that we see sort of in many places nearly a quarter of survivors report being arrested when they have tried to report intimate partner violence or other kinds of interpersonal violence. Next slide. I've spoken to this a little bit already, but pretrial incarceration and money bail disproportionately impacts marginalized communities. And that's for a lot of reasons. It's partially who police and prosecutors think look like victims and who they don't, the ways that racism and sexism intersect to mean that Black women are often deemed to be aggressive, that they're much less likely to be seen as victims or survivors and more likely to be seen as perpetrators when they stand up for themselves. And we see that both in people's stories, but also in the data. In a variety of studies, we see that just the vast majority of survivors who are arrested are Black and brown or low income. And so it just correlates with the ways that the criminal legal system may work for some survivors and then operates really to the detriment of others. Next slide. We've also spent a good deal of time thinking about non-citizen survivors and what it means when somebody is incarcerated pre-trial and what that can mean for their immigration status, what it can mean for the possibilities of deportation. We worked very closely with organizations on Long Island, particularly who are thinking at this intersection. And one of the leaders of the work in Long Island was a man named Angel Reyes, who does a variety of amazing advocacy work on Long Island. His mom was arrested for driving without a driver's license. She was undocumented and couldn't get access to one. And they lived on Long Island. It was the only way she could take her kids to school to get herself to work. Money bail was set. It was a couple of $1,000s. Angel was a teenager at the time, and he managed to scrounge up the money from his neighbors, from his community. But by the time he went to go pay her bail, her case had already been transferred to ICE. And she sat in the Suffolk County Jail for 6 months and then was deported. And so we see the intersections across a range of issues about what these kinds of carceral practices can do to survivors and do to families. Next slide. Spoke to this one a little. I'm unlike Anne. I'm not as good at sticking to my own slides. But one of the things that we think about a lot is what does safety look like? And to Anne's point, safety for survivors, but also across the board, looks like housing, looks like healthcare, looks like education, looks like stability and agency, and that pretrial detention, by depriving people and their families of that stability, by prompting the loss of jobs, the loss of housing, can undermine the safety of both families and of their communities at large. Next slide. And then we've seen this play out with survivors who have had an abusive partner arrested, and the kinds of instability, who have not wanted that, and the kinds of instability that gets created there has exacerbated the violence and the harm of that relationship. And so while some survivors have found utility in the criminal legal system, we've seen it act in opposition to the safety of some. Next slide. And so I've just excerpted here. We've spent most of this time talking about bail, but I just want to speak very briefly to discovery. So discovery relates to the evidence in your case. And for decades, New York had some of the worst discovery legislation in the country, which meant that people were not entitled to the evidence in their case until the eve of trial. And they were not entitled to any of the evidence prior to a plea deal. And so this meant that people were either going to trial without having had the adequate means to prepare, or they were facing a decision about a plea deal without even the basic facts of the case. And this meant specifically for criminalized survivors like Priscilla, like Eileen, that they didn't have the evidence they needed to be able to speak in their own defense. And that the lack of discovery, about the lack of evidence and the coercion of plea deals doesn't serve the interest of justice. Wrongful convictions don't serve the interest of justice. Wrongful plea deals don't serve the interest of justice. Survivors who have been criminalized, who don't have access to the evidence they need to demonstrate their innocence, none of that serves the interest of justice. And so this was part of the interest in various of the survivor advocacy organizations who worked on these bills, of making sure that not both for sort of the fairness of all New Yorkers to have the evidence they needed, the due process they needed, but specifically for criminalized survivors, why it was important to be able to get access to evidence early on in a case. Next slide. And so I'll just wrap up by thinking about sort of how have we been trying to, and how have the survivors that we've talked to and worked with and the organizations who have been working with us have been trying to think sort of what do we mean by safety and what really supports safety, and what does it look like for us to take part in fights for affordable housing, in fights for healthcare, in fights for educational access, in fights for investment and community investment in communities that have been divested from for decades, and the ways that it is those investments that contribute to the long-term safety and stability of individuals, of families, and of whole communities. So I'm now going to pass it to Insha.
Hi, everyone. I'm Insha, and I'm so glad to get to talk after Anne and Katie because they basically have said everything. Selena, if you don't mind scooting back to, I just want to sort of stay on this page for a second because I want to talk a little bit about what grounds me in this work and what our hope is for this moment that we're in with widespread criminal justice reform in New York, but hopefully like an opportunity to do much more than just think about changing the criminal justice system, but all of the other systems that we know survivors and others who are impacted by the justice system rely upon for safety and justice and support and equity and to respond to people's basic needs. I was a public defender up in the Bronx for many years, and I represented many people who were accused of and convicted of domestic violence, of intimate partner violence, of sexual assault, of other offenses that truly harmed people. And oftentimes in doing that work, I would talk to the people who were harmed by the people I represented. And what always felt so frustrating and just left me feeling so empty is that we had very little to suggest that people who are survivors, people who are harmed, can turn to other than the prosecutor who they were already working with, or law enforcement who they might already be working with, and who weren't giving them any options either. And so these reforms, and I will talk about the sort of nitty-gritty of the new bail law, the new discovery law, and hopefully provide you all with some talking points about the laws themselves to clear up any misconceptions that are out there and to make sure that there's sort of widespread education. But I think beyond the new laws and legal change, there's a real opportunity for us to think about how do we really shrink the sort of control and the footprint of the criminal justice system and really invest in all of those other systems that are community-based, that are responsive to people's needs, that are responsive to harm, that have really, we just have marginalized and not looked at because we've invested so much in the criminal justice system for so long in this country and for so long in this state. And so my job at Vera has been to work with prosecutors, with judges, with defense attorneys to train them on these new laws, to quell some of the fears, to address some of the fear mongering. And so that's the lens in which I'm going to share some of the talking points that I've been going around the state in the past 6 months, talking to folks, and hopefully that they are valuable for you all too. So Selena, next slide, please. So I love this picture of Assemblymember Latrice Walker and many, many advocates standing behind her on the day that the state moved forward to say, yes, we're passing bail and discovery reform, because it gives you a sense of just how diverse the support is for these new reforms. It's hard to remember that in this moment when in the press we're seeing every day yet another story of fear mongering, to remember that there is widespread support for these reforms. And the truth is, come January 1, 2020, all of this fear mongering will sort of be shown for what it is, which is fear mongering, and that we know that the sky won't fall down. Things will be fine. But it's on us to actually make sure that with these reforms, we do more than fine, that we actually sort of engage in a moment of transformative change. So next slide, please. Overall, Katie talked about how many people there are in jail across New York State. What we anticipate is if these reforms are done right between bail and discovery, there will just simply be thousands and thousands fewer New Yorkers in jail, maybe upwards of 40% fewer people in jail. And the opportunity there to say we're not going to rely on incarceration, we're going to use other tools, other means to actually deliver safety is a really amazing opportunity for us, since we know the system that we have, which is 24,000 people in jail today, doesn't actually deliver the kind of safety that we would all want to see, especially not for survivors of domestic violence and intimate partner violence and sexual assault. So next slide, please. And one of the things that we've been hearing a lot is that, well, we have to rely on jail and prison. We need that as an option to deliver public safety. And one of the things I do all the time is look to New York City to say, well, back in 1992, we had upwards of 22,000 people in jail in New York City on any given day. And you can see what the crime rate was back then. There were over 400,000 arrests back then. There were far more people in jail. And then you'll see that graph sort of plummets over time. And we have seen a 78% decline in crime in New York City since the early 1990s. The next slide. Selena, next slide, please. And then what we've also seen during that same time is the jail population has declined concurrent with the decline in crime. We are now down to having about 7,000 people in jail on any given day in New York City. And we've also seen public safety has increased in that same period of time. And so what we know from New York City, and we've seen this in other parts of the state, like Tompkins County, which is Ithaca, in places, in other places like Buffalo, Erie County, that have invested in resources that are not the jail and not incarceration. We've seen both the number of people behind bars decline as well as public safety increase. And so it's a myth that we need jail to deliver public safety, and we have numbers, hard numbers to back that up. Next slide, please. And so many times I've heard people say, well, we just can't make these reforms happen. It's too hard, the state is too big, the way that local counties work is too different, and what happens in New York City isn't going to work everywhere else. And I point people to the example of Tompkins County, where several years ago they were facing a question of overcrowding at their local jail, and they were making the decision, do we build a new jail to the cost of, over $50 million, or do we invest in other things? And so Tompkins County made a very concerted decision from the county legislature to say, we're going to put about $900,000 each year into alternatives to incarceration. And that is everything from their pretrial services program to community-based treatment and support. And what they saw is in just literally a couple of years, their jail population went down from 92 people in jail on any given day to 56. And again, crime rates continue to decline in Tompkins County, and there's just more public safety. And so I point people to that example to say, we're going to see fewer people in jail because of these reforms. And if Tompkins County is any tell, and it is, we will actually see crime rates continue to decline and investments in communities deliver public safety as we want to see it. So next slide, please. So what I'm going to do is first spend about 6 minutes, hopefully I will try and be tight on this, just giving you highlights of the new bail law, and then about another 6 minutes giving you highlights of the new discovery law so that everybody feels comfortable sort of saying, here are the basics of the new law, here are the ins and outs, and here's specifically what it means for survivors of domestic violence, of intimate partner violence, of other kinds of sexual violence. And then I want to make sure that we leave lots of time at the end. I know we wrap at 1:45, and I'm already seeing great questions come up in the chatter, so I will make sure to cut myself off at 1:25 so that we have lots of time for Q&A. Next slide, please. So this is a question that both Anne and Katie have answered, with a very clear, money bail does not make us safe. It simply privileges wealth, it privileges white people in this country, and it privileges, frankly, injustice. And there's a really concrete example from our neighbor to the west, New Jersey. They enacted bail reform in 2017, and what they've seen in the 3 years that they have done bail reform is there's 30% fewer people in jail, and they have far fewer arrests now, and they have far fewer sort of issues of serious crime, like crime has declined as well as the use of jail, and they've taken money bail essentially off the table for the vast majority of offenses. And so I think it's good for us to just, again, look to recent history to say, here are concrete examples of other places that have done what we are going to do. I think New York has an opportunity to do it even better than places like New Jersey, but these are good examples for us to quell, again, some of the fear-mongering and some of the concerns. Next slide, please. So, key aspects of New York's bail law. I think it's important to group it into sort of 4 key parts. And again, if anybody has specific questions, please ask them after, or feel free to reach out to any of us offline, and we'd be happy to talk more. So one big sort of change to the law is the mandate of appearance tickets. And New York has always had the provision of appearance tickets in the law, where law enforcement, police officers, when they make an arrest for a misdemeanor or a low-level felony offense, they can choose to give a ticket to somebody, which means you get let go literally within just a couple of hours, and you get to come back to court on another date. You can imagine that for somebody who has children, somebody who is working a job, somebody who has a home to get back to, that the difference between being able to be released after an arrest within just an hour or two versus sometimes upwards of 24 hours before you see a judge is all the difference to making sure that your family and your children are okay, to making sure that you still have that job, to making sure that your housing is okay. And so now under the new law, police officers no longer have the discretion. They are actually required to give these appearance tickets in the vast majority of misdemeanor and nonviolent felony offenses, with some notable exceptions, which is in a later slide. And those notable exceptions are around concerns of safety of survivors, safety in terms of DWI arrests, things like that. So there are some sort of provisions in the new law built in to specifically address the concerns that people have about survivor safety and making sure that there's an ability to do safety planning properly, issue orders of protection, things like that. Those are all built into the new law. The second key aspect of New York's new bail law is mandatory release on a wide swath of offenses. So basically, most misdemeanor, nonviolent felony, and even some violent felony offenses, judges no longer have the option to set bail or to detain people. And what this actually opens up, because we know that incarceration isn't what delivers safety, is it opens up a conversation to say, what does this individual who's accused of a crime or accused of committing harm, what specific resources and services and supports can we offer them to actually sort of address the underlying issues that are going on that led this person into the system? And sometimes those underlying issues are over-policing and over-criminalization and over-enforcement, but sometimes they really are other underlying issues that are going on for that person. And there's actually an opportunity to creatively address those issues as opposed to just set money bail or rely on jail to sort of press pause on that issue, but to not actually have any real meaningful response. And so the third thing is that judges can now impose specific non-monetary conditions of release. So that expansion of pretrial services, and to Anne's point, I think it's so important to know what pretrial services resources are available in your county, in your community, both for individuals accused of crime as well as those who are harmed by crime. We have an opportunity to really change that moment of arrest and the court system to actually invest in saying, how can we respond in a different way, in a more holistic, caring, long-term sort of investment in the overall well-being of people and therefore our communities. And then the fourth significant change to the new bail law is for the cases where money bail can still be set, which is most violent felony offenses, some domestic violence offenses, and also some sex-related offenses. If judges are going to set bail, and their ability to set bail is far more limited in the new law than it is right now under our current law, but judges, if they're going to set bail, they have to consider a person's ability to pay, and they have to consider more affordable forms of bail. I see one of the folks said there are 8 types of bail in New York State. It's actually 9 types of bail, and you're completely right that only cash bail and insurance company bail bonds, so go-no bail bondsmen, are the kind that are used most often here in New York. And with the new law, judges, if they're going to set bail, are now going to be required to set either what's called a partially secured bond, which is you put up no more than 10% of the bail amount to the court, and you actually get that money back at the end of the court case, and it's not lost to the bail bondsman as it currently is, or even an unsecured bond, which research, and Vera has done a lot of research on this, shows that people don't have to put up any of their own money. They still come back to court. And so these 2 new provisions will actually, I think, make a huge difference in making sure that money bail in and of itself isn't the sort of coercive and deeply unjust force that it currently is under our system. Next slide, please. So I said that there were some exceptions for the appearance ticket mandate, and here's what the exceptions are. So I'm just putting that there, and you all can have this PowerPoint to the extent that it's helpful as a little primer on the new law. Next slide. Again, so mandatory release, I have a little bit more information for you on what are the misdemeanors and nonviolent felonies, and even some violent felonies that are now going to be subject to mandatory release. Next slide, please. And so non-monetary conditions of release. I think this is really important for all of you who are advocates of survivors and work very closely with them about assessing pretrial needs. And as Anne said, the importance is really to do that in an individual way, in a holistic way, in a really thorough way. There's no checklist for this. This has to be a deep and individualized and two-way conversation. But so just so folks know, there are some pretrial conditions that judges can impose, such as supervision by a pretrial services agency, restrictions on a person's travel, and then restrictions on firearms or possessing a dangerous weapon. That's also part of the new law. And I think that that might be especially important in cases where there is intimate partner violence, just to know that that is an option that can be imposed by the court on the person who's accused of committing the harm. And then electronic monitoring. I know folks have been talking about this a lot because the new law, it's the first time that electronic monitoring is explicitly part of our bail law. And so the charges that qualify for electronic monitoring under the new law are all felony offenses, misdemeanor domestic violence charges, misdemeanor sex-related offenses, and then any misdemeanor where a person has been convicted of a violent felony offense within the past 5 years. Here's what I will say about electronic monitoring as somebody who is deeply steeped in research, and I do work on this nationally, which is the research on electronic monitoring is really thin, and it doesn't show that electronic monitoring actually delivers more public safety, that people do better on pretrial services or being released with electronic monitor than not. And it especially doesn't deter people from, while they're out on new conduct that might actually cause somebody harm. What we do know deters people, what we do know addresses the underlying reasons why people might be in the criminal justice system accused of a crime in the first place, is actually addressing those underlying issues with things that are much more individualized, that like counseling, like treatment. All of those things actually have been shown to have far better outcomes than an electronic monitor. And I think that's important for you all to know, because I know in my conversations around the state, especially law enforcement and DA's offices have been pushing for more capacity and more funding for electronic monitoring. But from the research, it doesn't actually show that it's effective. And I would hope for that money to actually go more into community-based treatment, counseling, and resources along those lines. Next slide, please. And so I said that there's still offenses, mostly violent felony offenses, where judges can still set bail, and they're called under the new law qualifying offenses. And so this is the list of those that you can take a look at later. Next slide, please. And then here is the specific language about judges if they do set bail, about ability to pay and setting more affordable forms of bail. And next slide. And just, I think, again, this is important for you all to know as advocates who work with survivors, that pretrial release has some bases for when it can be revoked. So somebody does get released who is accused of a crime. If they are out pretrial, a judge can revoke that pretrial release if there's a hearing and it's found that the person has willfully and persistently failed to appear in court, has violated an order of protection, and there's a new charge filed of criminal contempt, which is an allegation of violating an order of protection, if they're charged with witness tampering or intimidation during the pretrial period, and then if they're initially charged with a felony offense, are released and then arrested again with and charged with another felony. Next slide, please. So I feel like that was a whirlwind, but I hope it's helpful to just hear a little bit of the highlights, especially as it pertains to your work. And I want to do the same with discovery. One of the constant fears I've heard from prosecutors especially about discovery is that it will impact survivor safety, that there will be less protections in terms of where they live, in terms of who they are, in terms of witnesses being known to the defense and to the person who's accused. Next slide, please. And here's what we know of other places that have done discovery reform and done discovery reform recently, like North Carolina. There was a great study done and asked of North Carolina prosecutors, how has discovery reform been for you? And what they basically said was, it's been fine. In fact, we really like it because there's no more having to pick and choose to say, what should I turn over? What don't I turn over? I don't have to play this game or worry about whether or not I'm in compliance with the requirements under the law of turning over information. I just turn it all over. If there is a specific piece of evidence that I am concerned about for a survivor or victim's safety, then we can actually take that to the court and ask for what's called a protective order, which is the same thing that's been passed under New York's new discovery statute. But in general, I really appreciate just being able to turn over everything and know that we are actually doing justice by everyone, including the person accused of a crime, to actually know what the evidence is against them and to be able to make decisions about their criminal case based on the full evidence. And I think that that, again, is to the extent that you hear concerns about discovery reform, will be onerous, will compromise public safety. I think it's really important to look to other examples to say, actually, we've done this and it's been just fine. Again, next slide, please. So 4 key aspects of New York's new discovery law. One is, and this is a radical difference between the law that we currently have, is early and automatic disclosure of discovery. And what that means is, as opposed to how discovery works now, which is prosecutors hold on to all of it until what's called the eve of trial, and about 95% of cases in New York don't even go to trial. So discovery really only applies right now to about 5% of cases, if that. Now it will apply to all cases, and that makes sense that discovery should be turned over early, it should be automatic, and it should be for everybody, including the person who decides to take a plea, not just for those who decide to exercise their right to trial. Another key aspect is a real beefing up of protective orders, and I'll talk a little bit more about them specifically a little later. There's also a change in the language about what are good cause safeguards, which are essentially when does discovery not get turned over because of concerns about a survivor's safety. And then there are far more explicit remedies and sanctions for non-compliance, meaning if prosecutors and law enforcement don't turn over discovery, here are some of the remedies, the fixes within the law for making sure that discovery is properly complied with. So next slide, please. This is the list of basically like how quickly discovery must be turned over. And it's essentially 15 days after an arrest or an arraignment. And then if the prosecutor has a particularly voluminous amount of discovery, meaning there's a lot of reports or there's more stuff that they need to get from the police officer, they can ask for an additional 30 calendar days to actually meet their discovery requirements. There's also a requirement on the person who's accused and their defense counsel to turn over what's called reciprocal discovery. And basically all of this is so much quicker as a timeline than what we currently see. Again, it leads to so much more fairness and transparency in the system, but it is certainly a huge sea change in terms of timeline. Next slide, please. And so this is the list of what's included in automatic discovery, and it's pretty much everything. The one thing that we've heard come up a lot is the disclosure of physical addresses. The truth is the way the new law is written is it doesn't require the actual sort of like address, street, and zip code unless the defense counsel can make a good cause showing of why they need that. The language is basically that there has to be adequate contact information. And so it's a conversation between the prosecutor and the defense attorney about what satisfies that. And again, the truth is we know that defense counsel, when they do get discovery, they get oftentimes contact information right now for victims and witnesses and survivors, and that there isn't sort of a huge threat to anybody's safety or threats of intimidation because of that. Next slide, please. And so safeguards. For one thing, prosecutors can redact certain sort of sensitive information. There are lots of safeguards built into this new law about how soon before a guilty plea discovery has to be turned over so that the person who's making the decision to take a plea or not actually gets time to review that discovery and use that evidence to inform their decision. And I think that's such an important safeguard that we don't have now. And then the other thing that we've heard come up a lot is this issue of access to premises. There is a clause in the new discovery law that says defense counsel and the person who's accused of a crime can request access to the premises, but it's with a lot of safeguards for the people who live at those premises or for a survivor. And so the safeguard is this, is that the defense counsel has to give notice to the prosecution and any impacted party. So if you are working with a survivor and the premises in question is her home or his home, there has to be notice first to the prosecution, and they have to get in touch with the person whose home it is. And then that can actually be brought to a judge to make a decision about whether that is necessary or whether there's discovery that's already turned over of the so-called crime scene that can, mitigate any need to actually go there. And if the judge decides, yes, there's additional information at the premises that isn't covered in the sort of paper discovery, if the survivor or the person who's impacted chooses to, they can have a law enforcement officer, a police officer there while the defense is there at the premises. So I want to spell that out explicitly because we've heard time and time again from prosecutors that they're especially concerned about that provision, and I want to be really clear about what that provision actually is. Next slide, please. So protective orders are the other safeguard that is really about victim and survivor safety and making sure that witnesses are safe. And so I can talk more about this sort of afterwards if people have specific questions, but essentially there is a broad provision under the new law that prosecutors, if they are concerned about danger to the safety of a witness, risk of intimidation, economic reprisal, bribery, harassment, unjustified annoyance, they can ask for a protective order with any of that discovery. There are great provisions and really explicit provisions in this new law for survivor and victim and witness safety in that way. Next slide, please. And just so you know, here are the remedies that the court can enforce if prosecutors don't turn over discovery in time or don't turn over all of it. So that you can explain to people that you are working with, if they do choose to move forward in a criminal prosecution, here's what they can expect as part of what will be turned over and also what will happen in a case because of discovery issues. And we expect that this stuff will come up a lot. As this law comes into place, it's brand new for everybody in the court system, from prosecutors to defense counsel, and we're sure there will be lots of litigation and challenges around the compliance with discovery. And I know that for folks who represent people accused of crime, they're having those conversations with the people they represent to say this might look different in terms of what you can expect from your court case. I think that same conversation needs to be had with survivors and victims who are part of a criminal prosecution to make sure that they understand what this means for them as well. Next slide, please. So there's a couple of frequently asked questions, and I won't belabor them because I actually think they've been answered by Anne and Katie really well. So the first one, next slide, is will these new laws compromise public safety? No, and there's a little talking point for why, which I think we've all covered with great gusto. The next slide, please. We've heard a lot of like, will these new laws be impossible to comply with? And no, it won't. It will take the system having to change itself to do business differently. And that is frankly a really good thing for all of us because we currently have a system that is bogged down and slow and doesn't deliver justice for people who are accused of a crime and doesn't deliver justice either or safety for people who are part of a prosecution of a crime. And then the last slide is, won't this cost a fortune? Next slide. Again, no, it won't. We've seen other places do this and they've managed to do this just fine, and that will be true for New York as well. So I'll stop there and I'll turn it back over and hopefully we'll have time for questions.
Anne, Katie, Insha, thank you all so much. We truly appreciate this offering. With that said, we'll go ahead and start with the Q&A portion of this webinar. So the first question was just around whether slides would be shared, and the answer to that is yes. So you will receive a copy of the slides in addition to the recording. One other question that came up is there somewhere advocates can find resources to support clients who are in jail? The usual go-to tricks are often not applicable. Do you all need me to repeat that again?
I would love to just know, do you mean people who are currently in jail who won't be after the new law is implemented, or people who will remain in jail still, and it's sort of the same challenge that we have now with people? I'm just curious what the person's asking so that we can be responsive.
It was an anonymous attendee, so I'm not sure who asked the question, but if you want to clarify, please go ahead and list that in the Q&A box so that we can get back to this question. So we'll move on to the next question. Next question is, what are the presenter's thoughts on the downside of bail reform and the potential for victims to be at risk when perpetrators are not in jail?
I can speak specifically to concerns that advocates have for survivors of intimate partner violence specifically. I think that those of us, I've been an advocate for survivors of intimate partner violence for over 25 years. And in all of that time, the research that I know to be true is affirmed by my practical experience. We all know that the vast majority of people who harm their intimate partner and interact with the criminal legal system are being charged with misdemeanor level offenses, meaning never, ever, ever have they ever had bail set on them, because the vast majority of people arrested for misdemeanor offenses don't have bail set on them, or on the occasion that they do have bail set, that bail is relatively low, and they often will pay that before they even make their way to county jail. So I also recognize that this is going to have not as significant of an impact on survivors of intimate partner violence, just because of the level of offenses that their abusive partners are typically charged with. For those survivors of intimate partner violence whose abusive partners are charged with more serious offenses and bail is set, and the survivors historically have really relied on that time in jail to marshal their resources, to activate their safety plan. It just requires us as advocates to be incredibly present and creative with them during that safety planning process when bail has not been set and they're not in jail. We have to remind ourselves too, though, that orders of protection will continue to be issued in most jurisdictions in all domestic violence cases. I absolutely know, and we all know this, that orders of protection do not modify everyone's behavior. Absolutely know that is true. But in the event that they do modify people's behavior, really taking advantage of the existence of that order of protection, it just requires, so I think the concerns is more for us as advocates, it's our responsibility to be more creative and present in our safety planning, recognizing that the physical separation that may have been afforded by bail won't exist in the same way. It won't actually be absent, but it won't exist in the same way.
I'll just add to that, and I think that that's exactly right, and especially the statistics about the vast majority of domestic violence offenses are charged as misdemeanors across the state. And the Center for Court Innovation did a really interesting study a couple years back about domestic violence arrests in New York City, and the vast majority of people who were charged with a DV offense were charged with misdemeanors. They were released, and even for folks who had bail set, the average length of stay in jail was less than 7 days. So it's not as if the current system actually takes people off the street who are accused of intimate partner violence, and that hasn't been historically a mechanism that, frankly, most survivors of intimate partner violence have benefited from if it does in fact work, which we also know from the research it doesn't really work. The one thing that I'll say about the new law that I think is really important and helpful for victims and survivors of intimate partner violence and other kinds of violence is the expanded capacity to actually do pretrial services. If we use that in a way where we're actually looking to, again, what's underlying this harm? Is it substance use issues, mental health issues, issues about power and control and other dynamics that we know exist in relationships where there is intimate partner violence? Can we use this opportunity of pretrial services to actually do work that is necessary and that we currently do outside of the justice system, if at all, and we put that burden entirely on survivors or on people accused and who have committed harm to actually do that themselves? We'll finally, I think, as a system, take responsibility, which I think is a really important opportunity for all of us.
Just to add very briefly onto what Insha said about pretrial services, which is that pretrial services have existed in a very small number of counties. They've existed in New York City, they've existed in Monroe County, they've existed in a couple of other places. And so what pretrial services will look like is still really up for shaping. And so sort of when I envision what really effective pretrial services will look like, it really focuses on supporting people getting back to court, particularly in rural counties where people don't have access to public transportation systems. That pretrial services is there to help make sure that people can get back to court. But this is also an opportunity for people in your counties where your organization is located to get involved in trying to shape what that looks like. What are the range of services? How can they be used to help support survivors, to shift behavior, et cetera? And that it's sort of that's what exactly those will look like is up for the shaping at this point. And so I really want to encourage folks to be part of the conversation about what nonprofit in your county could take on pretrial services and what could they offer and how are they connected to different organizations doing work already.
Thank you all. The next question is, the presenter Ann mentions that this is an opportunity to build relationships with other people in the criminal justice system, such as defense attorneys. How would victim advocacy organizations manage this? Because in my organization, if the victim is a defendant, we are not able to work with that victim with regards to the crime they were charged with. That is because we have to be seen as an organization working for victims, not defendants. The victim is still eligible for other services, but we would not be able to advocate on their behalf to their defense attorney or accompany them to the court appointment for a crime they were charged with.
I'm very grateful for whomever asked this question, because this is one of my favorite things to talk about. And as an advocate, I recognize the bind that so many of us are put in. And I really think that this is an opportunity for us as advocates to really stand in our power and say that the criminal legal system is not in the business of telling me who is a survivor and who isn't a survivor. The label of defendant is an imposed label by the criminal legal system and sometimes has no bearing on someone's survivorship. So I think it's really important for you to examine, and we've done this at STEPS, and I've worked with lots of other anti-violence organizations to have done this, to really examine the origin of these policies that say we are prohibited from working with people who are labeled defendants. And stand in our power and say, we as advocates know how to assess for someone's survivorship. And simply because a system has labeled someone a defendant doesn't erase their survivorship. So does your funding prohibit you from working people who are labeled as defendants? Very often, if you dig into that, you will find that there is no real prohibition against you working with people who are labeled defendants. The prohibition is about working with people who are engaging in a patterned behavior of coercive control designed to gain and maintain power and control over their intimate partner. Those are the people, those are abusive partners. So those are the people that we may not be equipped to support. We are absolutely equipped to support survivors of intimate partner violence who have been arrested because they continue to be survivors. So I think you need to interrogate these policies, figure out the origin of these policies at your work. Are they funders specific? Because most funders don't prohibit you from supporting a survivor simply because they've been arrested. So definitely dig into those things and stand in your power and say that you can determine as a survivor advocate who a survivor is.
Thank you, Ann. So here's like a question and a comment. I've heard from a number of victim advocates and individuals in law enforcement in the area where I work. They are concerned that common misdemeanor charges that batterer often faces, criminal obstruction of breathing, criminal possession of a weapon, unlawful imprisonment, endangering the welfare of a child, assault in the third degree, will result in no monetary bail and the abuser will be free on bail. There are concerns that this will jeopardize the victim survivor's safety, won't allow them to flee to safety, and won't help hold an abuser accountable for their actions. I have some differing opinions that are in line with what the presenters have talked about today, but I'm wondering what your response is to this concern.
So I talk about this all the time with prosecutors and with law enforcement, with judges, even some defense attorneys who I've heard say, look, I'm a little concerned that if we don't have bail, I don't know how I'm going to get this person back to court. And so again, I think looking at places that have done this, so New Jersey eliminated the use of money bail. They still have, unfortunately, domestic violence arrests. And the vast majority of those domestic violence arrests are being released pre-trial. But again, there's now an opportunity to supervise people to make sure that they do come to court. And what we know from court appearance rates in New York City, 88% of people just come back to court. Everywhere else that actually looks at its statistics, judges only remember the few cases where people don't show up, and they don't remember the vast majority of cases where people do show up and people don't flee. It's not a thing that statistically is at all significant. So I actually think that concern is one of just, again, a sort of a reactionary, it's just a reaction to change and to a system that looks very different from the one that they know and feel comfortable with. As to the sort of concern about victims and survivors, again, the fact that we will now have an opportunity to do more with people who are released pre-trial than to simply let them pay $500 or $1,000 or $5,000 bail, whatever it is, but to actually engage with the person who's accused of committing harm is a much better investment long-term in that relationship, in that family, in public safety sort of writ large. And again, New Jersey has done this. They have specific sort of pretrial services programs that are for people who are charged with domestic violence and intimate partner violence, and the results have been excellent. And those are things that I know we are looking at in different parts of New York. I don't think we've done nearly enough to sort of help shape that wherever you are. Again, I think Katie's, encouragement to sort of get involved to help shape what that looks like is a really important one. Mm-hmm. We have a chance to really shape it in the right ways so that we have a system we can feel actually really does deliver safety in the way that we define safety, which is not incarceration, which is how law enforcement and prosecutors have traditionally defined safety.
Thank you, Insha. Do we know what the average caseload of a North Carolina prosecutor is compared to an NYC prosecutor?
I don't know, but I will actually say it's probably more than what prosecutors have here in New York. Most places have a far more overburdened criminal justice system than what New York has, which is shocking, I know, for all who look at the system here.
Thank you. What are some examples of pretrial service agencies that provide supervision over the alleged perpetrator? Also, what are the steps that those agencies may take to ensure proper supervision and hence safety for the survivor? And how might we find out who is our pretrial services agencies in our counties? And I can repeat any of that if you need me
to. Either of you, do you want me to chime in?
I think that's you, Insha.
Okay, so right now we don't have any formal pretrial services organizations in New York State that specifically take domestic violence cases. We will have that in New York City come January 1, 2020. And I know Monroe County is working on doing a very specific sort of intake assessment for people who are accused of domestic violence. So we'll have a couple more examples. However, informally, I know that defense attorneys across the state have been really creative and industrious in sort of connecting with counseling and other kinds of community-based services for people they represent who are accused of domestic violence and intimate partner violence offenses. And what we've seen from those examples, and I'll speak for myself as a former defense attorney, is those were the cases where we just saw much better outcomes, both for the person that I represented because they were actively engaging in something to address the harm that they had either were accused of committing or had committed. And in terms of how much we were in touch with survivors, how much they appreciated what that meant for them in terms of either a decision to stay together or not stay together, but for their family overall. And so unfortunately, we don't have great examples of it from New York State. We will start to. come January, but we do have good examples in New Jersey. There's a great restorative justice domestic violence program in Atlanta. These examples exist. They just have never been invested in the way that more traditional electronic monitoring and other kinds of pretrial supervision mechanisms have been invested in. So again, I think we have an opportunity to really build the system that we want to see.
And just a follow-up question to that says, how would one go about trying to get involved in shaping pretrial services? I wouldn't even know where to start.
I can do that as a person who has been trying to do this around the state. There has, in sort of the case with any sort of sizable change in a big state with a lot of counties, it's looking pretty different in different places. But what the process appears to be is that the county executive's office in your county is selecting pretrial services. In many of the places, and I say this with a little bit of heartache, but in many of the places that have not had pretrial services, the county is just selecting probation because they exist. I both really don't think that probation is the right house for pretrial services because they're doing something really fundamentally different. There have also been a number of probation directors around the state who have testified to say they also don't think they are the right house for pretrial services. And so my suggestion would be, and this is to Anne's point for folks to get a chance to step into their power, I would reach out to your county executive and schedule a meeting. If you feel like you need a little bit more muscle to do that, reach out to a couple of other organizations in your county. But if you reach out to your county executive's office, and you can Google them and get their contact information, and say, we, this organization, want to meet with you about pretrial services, or we, this group of 3 or 4 organizations, want to meet with you about pretrial services, you'll be able to get that meeting, and you can learn at that point what is being planned. Is it sort of a stopgap plan? You can push at that point, for example, for an RFP process so that it is not indefinitely probation, but there's an opportunity for a nonprofit to be pretrial services. You can find out whether that already exists or advocate for it. And I assume, Selena, that you'll share our contact information, but I would love to support anybody who is interested in and has not historically had meetings with your county executive and trying to figure out sort of how to push these sort of systems changes. I would be honored to help support anybody who would be interested in that.
Thank you, Katie. Yes, I will be sharing your contact information as well as the other presenters. And so we have to come to a close now, but what we'll do is send along any unanswered questions to the presenters, who will then, need some time, especially in light of the holidays, to look over them, answer them, and then once we have them all answered, I will send that back to all attendees who joined today. Thank you to all attendees for joining us today. We appreciate your participation, and I want to extend a special thank you to our presenters. Thank you so much for being here with us today and for all the valuable information you provided. Happy holidays to everyone, and take care.